Arkansas Statutes, Rules, and Regulations Pertinent to Life Insurance Only. This section will explain some of the major regulations that apply exclusively to life insurance in this state. By the end of this section, you should be able to explain the basic laws that apply to different types of life insurance products. Terms to know creditor: a lender of funds debtor, a borrower of funds dividend, a payment made by a policy, distribution of profits or return of unused funds. Endowment contract: type of whole life insurance that matures early, before insured's age 100. Lapse: policy termination due to non-payment of premium. Maturity date: the date when the final payment on a loan becomes due and payable. Nonforfeiture values: benefits in a life insurance policy that the policyowner cannot lose. Participating policies: policy owners are entitled to return of dividends. Policy proceeds: in life insurance, the death benefit. A. Life insurance policies. 1. Definition. The Arkansas Insurance Code defines life insurance as insurance on a human life. The transaction of life insurance includes the granting of endowment benefits, benefits for expenses incurred in connection with death, additional benefits in the event of death or dismemberment by accident, additional benefits in the event of disability, and optional modes of settlement of proceeds of life insurance contracts. Life insurance premium is defined as the consideration for insurance, by whatever name called. Any assessment, or any membership, policy, survey, inspection, service, or similar fee or charge in consideration for a policy is deemed part of the premium. 2. General provisions. All individual life insurance policies issued to Arkansas residents or issued by life insurance companies organized under the laws of Arkansas must contain the names of the parties to the contract, the subject of the insurance, the risks insured against, the time when the insurance takes effect and the period during which the insurance is to continue, the premium or premium deposit, and the policy fee, if any. All life and accident and health policies and annuity contracts issued by domestic insurers must be designated by a combination of letters or figures, or terms identifying the respective forms of policies, together with the year of adoption of the form. Whenever changes are made in the form, the designating letters, figures, or terms and year of adoption must be correspondingly changed. All individual life, annuity, and accident and health policies, excluding Medicare supplement, variable life and variable annuity contracts, must have a notice prominently printed on the first page of the policy stating that a policyholder has the right to return the policy within 10 days of its delivery if, after examination of the policy, the policyholder is not satisfied for any reason. This is also known as the policy's free look period. If a policyholder returns the policy within 10 days of the policy delivery, it will be void, and the parties will be in the same position as if no policy had been issued. A policy may contain additional provisions not inconsistent with the insurance code if they are required to be inserted by the laws of the insurer's domicile, necessary due to the manner in which the insurer is constituted or operated, in order to state the right and obligations of the parties to the contract, or desired by the insurer and neither prohibited by law nor in conflict with any provisions required to be included therein. You have already learned about life insurance policies and provisions, clauses, and options that apply to most policies. However, there are some additional state-specific provisions required in life insurance policies issued in this state, and they are as follows. Integrity of contract. Integrity of contract and alteration of contract provision states that the policy and the application constitute the entire contract between the parties, and all statements in the applications are considered representations, and not warranties, except for fraud. Agents do not have the power or authority to waive, change, or alter any of the terms or conditions in the policy except that at the option of the insurer. The terms or conditions may be changed by an endorsement or rider signed by an authorized officer of the insurer. Assignment. A policy may be assignable or not assignable, as provided by its terms. The beneficiary may be changed upon the insured or policyowner's request, by a pledge or transfer of title. If the beneficiary is changed, the insurer must deal with the assignee as the owner until the insurer's home office has received written termination of the original assignment. Dividend provision. No later than by the end of the third policy year in participating policies, such as those issued by mutual companies, the insurer must annually pay the divisible surplus to the insured, in cash or applied to other dividend options as provided by the policy. Payment of proceeds. Payment of proceeds. Upon the insured's death, the insurer must pay all due benefits within a reasonable time. In no case can this period exceed 30 days from the date proof of death of the insured has been furnished to the insurer. The insurer must also refund unearned premiums, for any period beyond the end of the policy month in which death occurred, in a lump sum no later than 30 days after the proof of death was received. Holding of proceeds. Any life insurer has the power to hold the proceeds of any policy under the agreement with the policy owner, or upon policy maturity, with the beneficiaries. X. Protection of beneficiaries from creditors. All individual life insurance policies must entitle the beneficiary to all proceeds due under the policy, regardless of any creditor's claims against the insured. A life insurer may hold the proceeds of any policy it issues, provided the insured agrees. These proceeds may be exempt from any creditor's claims against a beneficiary other than the policy owner. Limitations of liability. Limitation of liability provision excludes or restricts insurers' liability for death resulting from specific causes. In addition to common exclusions, such as war, aviation, and hazardous occupation, insurer may exclude death while the insured is a resident outside the continental United States and Canada. Suicide provision excludes liability for death caused by the insured's suicide if within 2 years of the policy issue. Policy loans. All life insurance policies that allow for policy loans must contain at least one of the following interest rate provisions: a provision permitting a maximum interest rate of 8% annually, or a provision permitting an adjustable maximum interest rate established from time to time by the insurance company as permitted by the insurance code. The rate of interest charged on a policy loan when the rates are established by the company, as permitted, may not exceed the higher of the published monthly average for the calendar month ending 2 months before the date on which the rate is determined, or the rate used to compute the cash surrender values under the policy during the applicable period plus 1% per annum. The maximum rate for each policy must be determined at regular intervals at least once every 12 months, but not more frequently than once every 3 months. 3. Standard non-forfeiture law. Non-forfeiture values are the benefits of a life insurance policy that the policy owner does not forfeit even if the policy lapses. All cash value life insurance policies issued in this state must include non-forfeiture provisions that are at least as favorable as the following. In the event of default in any premium payment for at least 1 year, a paid-up non-forfeiture benefit will become effective as specified in the policy unless the person entitled to it elects another option within 60 days after the due date of the premium in default. Upon policy surrender within 60 days after the due date of any premium payment in default, after the premium has been paid for at least 3 full years in ordinary insurance or 5 years in industrial policies, the insurer will pay, in lieu of any paid UP non-forfeiture benefit, a cash surrender value. If the policy is paid up or is continued under a paid-up non-forfeiture benefit, the insurer will pay a cash surrender amount if the policy is surrendered within 30 days after the policy anniversary. A mortality table, interest rate and method used in calculating cash surrender values and the paid-up non-forfeiture benefits must be available under the policy, and a statement that the policy's cash surrender values and a paid-up non-forfeiture benefits meet the minimum value and benefit requirement for the state in which the policy is delivered. The insurer reserves the right to defer the payment of any cash surrender value for a period of 6 months after demand with surrender of the policy. The Arkansas non-forfeiture law does not apply to the following: reinsurance, group insurance, pure endowment contract, or annuity or reversionary annuity contracts. 4. Life advertising. In connection with the selling of life insurance, producers have the following responsibilities: inform the purchaser that the producer is acting as an insurance producer, and give the purchaser the full name and address of the insurer. Give to the purchaser, before the delivery of the policy, a written proposal describing the elements of the policy as well as the insurer's name, address, and description of coverage. It is considered to be a deceptive practice if an insurer or producer does any of the following: uses any system for comparing the cost of insurance that does not recognize the time value of money, unfairly compares dissimilar policies or riders, describes a participating policy dividend as other than a refund or return of part of the premium paid, and which is not guaranteed and is subject to periodic change, falsely disparages competitors, their policies, services or business methods. Refers to an insurance premium as an investment, deposit, or savings. Or indicates that cash or loan values are death benefits or that those values are available in addition to the face amount of the policy. B. Group life. 1. Eligible groups in Arkansas. All group life insurance policies must conform to one of the following descriptions. Employee groups. Policies issued to an employer, or a trustee of a fund established by an employer, to insure employees and subject to the following requirements. The premium must be paid by the policyholder either wholly from the employer's funds or from the insured employee's funds or both. In policies in which the employer pays the entire premium, all eligible, insurable employees must be insured, and an insurer may exclude or limit the coverage on any individual whose evidence of insurability is not satisfactory to the insurer. Debtor groups. Policies issued to a creditor are subject to following requirements. The policy premium must be paid by the policyholder either from the creditor's funds or charges collected from the insured debtors, or both, and an insurer may exclude or limit the coverage on any individual whose evidence of insurability is not satisfactory to the insurer. Labor union groups. Policies issued to a labor union to insure its members require the following. The premium for the policy be paid by the policyholder, labor union, or from funds contributed by the insured members specifically for their insurance, or from insurance, or from both. A policy in which no part of the premium is to be paid by the members specifically for their insurance must insure all eligible, insurable members, and an insurer may exclude or limit the coverage on any individual whose evidence of insurability is not satisfactory to the insurer. Trustee groups. Group policies issued to the trustees of a fund established by two or more employers or by one or more labor unions or employers to insure employees or members of the union, are subject to the following requirements. The premium for the policy must be paid from funds contributed by the employer of the insured persons, or by the union or similar employee organization, or by both the insured and the employer or union. A policy in which no part of the premium is to be paid by the insured members specifically for their insurance must insure all eligible, insurable members, and an insurer may exclude or limit the coverage on any individual whose evidence of insurability is not satisfactory to the insurer. Association groups. A group life insurance policy may be issued to an association to insure the lives of a group of individuals that has been organized for reasons other than obtaining insurance so long as the group meets the following requirements. The group has 100 or more members. The group has been a group for more than 2 years. And the group has a constitution and bylaws. A group life insurance policy may be sold in Arkansas unless the commissioner finds any of the following. The group policy would not be in the best interest of the public. Issuing the group policy would be unsound actuarially or economically, and the benefits are unreasonable in relation to the premiums charged. Life insurance coverage may be extended to insure spouses and dependents or minor children of the insureds, subject to the following. The premium must be paid by the employer or union, the insured employees, members, or both employer or union and insured or member, and an insurer may exclude or limit coverage on any spouse or dependent child whose evidence of insurability is not satisfactory to the insurer. 2. Conversion rights. Another characteristic of group insurance is the conversion privilege. If an employee terminates membership in the insured group, the employee has the right to convert to an individual life policy without proving insurability. The insurer will determine what policy an employee may convert to, but it must be issued at a standard rate. The face amount or death benefit will be equal to the group term face amount, but the premium will be higher. The employee usually has a period of 31 days after terminating from the group in order to exercise the conversion option. Other rules that apply to the conversion of a policy include if the policyowner dies during the conversion period, the death benefit must be paid, whether or not the application for an individual policy was completed. If the master contract is terminated, every individual who has been on the plan for at least 5 years will be allowed to convert to individual insurance of the same coverage, and if active employment is required for coverage, and an individual becomes disabled, the insured may continue coverage for up to 6 months after total disability. The conversion privilege is also available to a surviving spouse or dependent if the employee has died or divorced. 3. Standard and required provisions and coverage. All group life policies issued in this state must include the following provisions. Grace period. A 31-day grace period for the payment of any premium, except the first, during which time the death benefit coverage will continue in force. Incontestability. The policy will be incontestable after 2 years from its issue date, except for non-payment of premium. Entire contract and statements of the applicants, insured. A copy of the application must be attached to the policy when it is issued, and the statements in the applications are representations, not warranties, and cannot be used in a legal contest unless that person or his or her beneficiary receives a copy of the statement. Evidence of insurability. The insurer may require evidence of insurability as a condition of coverage. Misstatement of age. In the event of a misstatement of age by an insured, an equitable adjustment of premium or benefits payable must be made. Certificate. Each person in the group will receive a certificate from the insurer summarizing the insurance protection, to whom benefits are payable and policy's rights and conditions, and payment of benefit. The insurer must pay death benefits to the insured's beneficiary or pay according to policy provisions if there is no beneficiary. The insurer may pay up to $10,000 to anyone appearing to the insurer to have incurred funeral or other expenses incident to the last illness or death of the insured. Payment of benefits provision. See credit life insurance. Credit insurance is a special type of coverage written to insure the life of the debtor and pay off the balance of a loan in the event of the death of the debtor. Credit life is usually written as decreasing term insurance, and it may be written as an individual policy or as a group plan. When written as a group policy, the creditor is the owner of the master policy, and each debtor receives a certificate of insurance. The creditor is the owner and the beneficiary of the policy, although the premiums are generally paid by the borrower, or the debtor. Credit life insurance cannot pay out more than the balance of the debt, so that there is no financial incentive for the death of the insured. The creditors may require the debtor to have life insurance. They cannot, however, require that the debtor buys insurance from a specific insurer. Know this: credit life insurance cannot pay out more than the balance of the debt. Subject to the acceptance of the insurer, the term of the credit insurance begins on the date when the debtor becomes obligated to the creditor, and the term of coverage cannot extend more than 15 days beyond the scheduled maturity date of the loan, unless the coverage is extended at no charge to the borrower. Replacement. Replacement means any transaction in which new life insurance or a new annuity is purchased and, as a result, the existing life insurance or annuity has been or will be any of the following: lapsed, forfeited, surrendered, or otherwise terminated. Reissued with any reduction in cash value. Converted to reduced paid-up insurance, continued as extended term insurance or otherwise reduced in value by the use of non-forfeiture benefits or other policy values. Amended so as to effect either a reduction in benefits or in the term for which coverage would otherwise remain in force or for which benefits would be paid. Or used in a financed purchase. Replacing insurer is the company that issues the new policy. Existing insurer is the company whose policy is being replaced. Duties of the replacing producer. Present to the applicant a notice regarding replacement that is signed by both the applicant and the producer. A copy must be left with the applicant. Obtain a list of all existing life insurance and/or annuity policies to be replaced, including policy numbers and the names of all companies being replaced. Leave the applicant with the original or a copy of written or printed communications used for presentation to the applicant, and submit to the replacing insurance company a copy of the replacement notice with the application. Each producer who initiates the application must submit the following to the insurance company with or as part of each application: a statement signed by the applicant as to whether replacement of existing life insurance or annuity is involved in the transaction, and a signed statement as to whether the producer knows replacement is or may be involved in the transaction. Duties of the replacing insurance company. Require from the producer a list of the applicant's life insurance or annuity contracts to be replaced and a copy of the replacement notice provided to the applicant. And send each existing insurance company a written communication advising of the proposed replacement within a specified period of time of the date that the application is received in the replacing insurance company's home or regional office. A policy summary or ledger statement containing policy data on the proposed life insurance or annuity must be included. In this state, It is illegal for an insurance producer to encourage an insured to permit an existing individual life insurance policy or individual annuity contract to lapse unless the insurance producer furnishes the policyholder a written and dated memorandum comparing the existing policy with the proposed policy signed by the producer and the insured. Files a duplicate of the memorandum with the company represented by the producer, which must retain the duplicate for 5 years, and sends a duplicate of the memorandum to the existing insurer. The memorandum must include the following: name of insurer as it appears on the policy, face amount of policy, and policy number or, if number is not available, type of policy. Chapter recap. This chapter focused on state-specific regulations pertaining to life insurance products. Let's recap some of the important requirements and processes. Individual life insurance. Life insurance provisions. Free look 10 days dividends must be available in participating policies by the end of the 3rd year limitation of liability. Suicide is excluded for the first 2 years of the policy payment of proceeds. Within 30 days after the insurer receives proof of death protection from creditors, beneficiary is entitled to policy proceeds regardless of any creditor's claims against the insured. Non-forfeiture law. Paid-up non-forfeiture benefit becomes effective in case of default of premium upon policy surrender within 60 days of default of due premium. The insurer will pay the policyowner a cash surrender value. Advertising must be accurate and not misleading. Specific rules apply to terminology and statements. Records must be kept on file for 4 years. Group policies. Eligible groups: employer-employee groups, labor unions, credit unions, and trustee groups. Associations. Debtor groups. Required provisions. Certificate. Each insured receives certificate of insurance summarizing policy benefits and conditions. Conversion within 31 days of policy termination. No evidence of insurability required. Death benefit payable to the designated beneficiary. Entire contract. Copy of the application must be attached to the policy. Grace period 31 days. Incontestability period 2 years. Misstatement of age. Benefit is adjusted. Credit. Life purpose and features. Insurance on a life of a debtor. Creditor is the owner and the beneficiary. Decreasing term insurance. Amount of coverage cannot exceed the amount of debt replacement. Purpose. Transaction in which a new policy replaces an existing policy that is lapsed, forfeited, surrendered, or terminated. Reissued with a reduction in case value. Converted to reduced. Paid-up insurance. Notice regarding replacement, provided by the agent. Record retention regulations. Thanks for watching.